Before we begin, a quick and important disclaimer. The following content is provided strictly for educational and entertainment purposes. This retrospective examines historical legal trends, social shifts, and case studies regarding matrimonial law and domestic history in the United States. It does not constitute legal, financial, or psychological advice. Laws regarding domestic relations vary significantly by jurisdiction and have changed drastically since the period discussed. Viewers are strongly encouraged to conduct their own due diligence and consult with a licensed professional regarding any personal, legal, or domestic matters. In 1960, if you walk down any suburban street in Levittown, New York, or the burgeoning developments of Orange County, California, you would see a landscape of perceived domestic perfection. The lawns were manicured, the station wagons were polished, and the nuclear family was the undisputed foundation of the American dream. But behind those heavy oak doors and pastel-colored curtains, a silent pressure cooker was reaching its breaking point. For most of the early 20th century, the divorce rate had remained relatively stable, but as the 1960s dawned, a seismic shift was beginning to fracture the very bedrock of American society. By the end of this decade, the way Americans viewed love, commitment, and the legal right to walk away would be unrecognizable. We are talking about a time when getting a divorce wasn't just a personal choice. In many states, it was a legal war that required you to prove your spouse was a criminal or a moral degenerate. If you couldn't prove fault, you were legally tethered to a stranger for life. Today, we look at the 1960s as a decade of revolution, but the revolution of the household was perhaps the most visceral. This deep dive solves a critical problem for the modern viewer. It provides the necessary historical context to understand why our current domestic legal system looks the way it does and how the no-fault revolution, which began in this era, continues to shape the economic and social outcomes of millions of American families today. To understand where we are going, we must first look at the legal and social cages that define the early 1960s. To understand the 1960s divorce landscape, we have to start with the fault system. Prior to 1969, the United States operated under a system of adversarial divorce. This meant that the law viewed marriage as a contract that could only be broken if one party committed a grievous wrong against the other. These grounds for divorce typically included adultery, physical cruelty, desertion, or incurable insanity. If you simply fell out of love, the law essentially told you to deal with it. This created a perverse incentive for spouses to spy on one another, hire private investigators, and engage in what was known as collusion. Consider the case studies from New York in the early 1960s. At the time, New York had some of the strictest laws in the country, recognizing only adultery as a valid reason for ending a marriage. This led to the rise of the professional correspondent industry. A husband and wife who both desperately wanted to part ways would hire a woman to go to a hotel room with the husband. A hired photographer would then burst into the room, take a picture of the husband and the other woman in a state of undress, even if they were just sitting on the edge of the bed reading a newspaper, and that photo would be presented to a judge as proof of infidelity. The system was built on the foundation of orchestrated perjury because the alternative was a lifetime of domestic entrapment. As the decade progressed, the social stigma of being a divorcee began to erode, but the economic hurdles remained monumental, especially for women. In the early 1960s, the feminine mystique, a term coined by Betty Friedan in 1963, began to articulate a problem that has no name. This was the deep-seated dissatisfaction felt by millions of educated housewives who felt their lives were being consumed by domesticity. However, the potential outcomes for a woman seeking a divorce in 1964 were often dire. In most states, a woman could not easily obtain a credit card in her own name, and if she left her husband, she often lost access to the family's wealth, as many assets were legally controlled by the male head of household. Divorce wasn't just a social risk. It was an immediate plunge into potential poverty. Historical trends during this period show a fascinating geographic workaround: the Reno divorce. Because the laws in states like New York or South Carolina were so restrictive, an entire industry of divorce ranches popped up in Nevada. Nevada had a residency requirement of only 6 weeks. A wealthy spouse would travel to a ranch in Reno, live there for a month and a half, obtain a quick decree under Nevada's more liberal laws, and then return home. This created a two-tiered system where the wealthy could buy their freedom, while the working class remained stuck in broken homes. This disparity became a primary driver for the legislative reforms that would eventually sweep the nation. By the mid-1960s, the tension between the law and reality reached a boiling point. The introduction of the oral contraceptive pill in 1960 had already begun to decouple sex from procreation, which in turn began to decouple the idea that sex and marriage were the only legitimate framework for a relationship. As the counterculture gained steam, the idea of personal fulfillment began to outweigh the traditional value of institutional stability. People were no longer asking what is good for the family, but rather, is this relationship helping me grow as an individual? Step by step, the legal community began to realize that the adversarial fault system was doing more harm than good. Judges were tired of presiding over theatrical trials filled with lies. Lawyers were tired of coached testimony. In 1966, a commission in California began studying the possibility of a no-fault system, where a marriage could be dissolved simply because of irreconcilable differences. This was a radical departure from centuries of Western legal tradition. It shifted the focus from who is to blame to is the marriage dead? The data from this era is staggering. Between 1960 and 1970, the divorce rate in the United States nearly doubled. This wasn't necessarily because marriages were getting worse, but because the escape valves were finally being opened. We must look at the specific case study of the 1969 Family Law Act in California, signed by Governor Ronald Reagan. It is a historical irony that Reagan, a man who would later become the standard-bearer for family values, was the one to sign the first no-fault divorce law in the country. This law eliminated the need to prove a wrong and effectively ended the era of the professional correspondent and the staged hotel photo. However, the transition was not without its casualties. In part one of this retrospective, we must acknowledge that the sudden shift to no-fault divorce often left women, who had spent decades as homemakers, without the alimony protections that the old fault system occasionally provided as a form of punishment against a wayward husband. The 1960s was a decade where the legal structure of the American family was demolished, but the new structure to protect the vulnerable was still being built. This period represents the messy, painful, and necessary demolition phase of the American household. As we move forward in this series, we will examine how these 1960s shifts led to the divorce boom of the 70s and 80s, the rise of the latchkey kid, and the fundamental restructuring of the American economy as women entered the workforce in record numbers to gain the financial independence that divorce required. The 1960s was not just a decade of peace and love. It was the decade where the American marriage was put on trial, and the verdict was that the institution could no longer supersede the individual. We are still living with the echoes of that verdict today. To truly grasp the magnitude of the 1960s transformation, we have to look at the sheer technical difficulty of ending a marriage in 1962. Imagine if you were a woman named Eleanor living in a quiet suburb of Chicago in 1963. To the neighbors, Eleanor has it all. A husband with a steady job at the local manufacturing plant, 2 healthy children, and a modern kitchen with a brand new refrigerator. But inside the home, the marriage has been spiritually dead for years. There is no physical abuse, there is no flagrant infidelity, and there is no abandonment. There is simply an irreconcilable void. In 2026, Eleanor could simply file for a no-fault divorce and begin the process of untying her life. But in 1963, Eleanor is effectively a prisoner of the state. Under the adversarial system that dominated the early 1960s, Eleanor could not just leave because she was unhappy. She had to prove her husband, Frank, had committed a specific legal sin. This created a culture of surveillance that turned private citizens into amateur detectives. In the early part of the decade, the private investigator industry flourished not just to catch cheating spouses for personal closure, but to gather the admissible evidence required by a judge to grant a decree. Investigators would use equipment that seems primitive today, like the Minix subminiature camera, to snap grainy photos through motel windows. These photos weren't just for leverage in a settlement. They were the golden ticket to legal freedom. If Eleanor couldn't prove Frank was a cheat or a brute, the court would literally refuse to divorce them. If they both wanted the divorce and tried to make it easy by agreeing on the facts, they ran into a legal wall called collusion. In many jurisdictions, if a judge suspected that a husband and wife were cooperating to get a divorce, he could dismiss the case entirely. The law demanded that one person be the victim and the other be the villain. This forced couples into a performance of hatred. They had to walk into a courtroom and testify under oath to the most humiliating details of their private lives, often exaggerating or outright lying, just to meet the high bar of legal cruelty. Historical trends from this era show that the definition of cruelty was the primary battlefield. In some states, physical cruelty was easy to define: a police report or a doctor's note. But mental cruelty was a gray area. It could be anything from a husband refusing to speak to his wife for weeks to a wife refusing to cook or clean. This led to a massive inconsistency in how laws were applied. A wealthy woman in a liberal urban center might find a judge willing to accept mental cruelty as grounds, while a working-class woman in a conservative rural county would be told to go home and try harder to be a better wife. This brings us to the economic trap. Imagine Eleanor again. Even if she manages to find grounds for divorce, she faces a financial abyss. In 1965, the legal and financial structures of the United States were heavily weighted toward the male head of household. Most women did not have their own credit history. In fact, it was standard practice for banks to deny a woman a credit card or a loan without her husband's signature. This wasn't just a social custom. It was a systemic barrier. If Eleanor leaves Frank, she might get a small amount of alimony, but she has no way to build a future. She can't get a mortgage for a small apartment. She can't get a car loan. Case studies from this period highlight that many women remained in toxic or even dangerous marriages not out of love or religious conviction, but out of a calculated fear of homelessness. The potential outcomes of a divorce for a woman in 1964 were often synonymous with a total loss of social and economic status. For those who could afford it, the solution was the migratory divorce. This created a profound class divide in American domestic life. If you had the money, you headed to Nevada. Nevada's laws were a deliberate economic strategy to attract divorce tourists. While other states required a year or more of residency before you could even file, Nevada only required 6 weeks. A wealthy spouse would check into a divorce ranch in Reno or Las Vegas. These weren't just motels. They were social hubs where people from high society would spend 6 weeks riding horses, swimming, and drinking cocktails while they waited for their residency to vest. On the 43rd day, they would walk into a local courthouse, get their decree, and fly back to New York or Chicago as a free person. But for the average American family, a 6-week vacation in Nevada was an impossible luxury. This meant that the rich could access a no-fault style freedom through a loophole, while the poor and middle class were forced to remain in the adversarial trenches. Another hidden layer of the 1960s divorce experience was the doctrine of recrimination. This was a particularly brutal legal concept that stated if both parties were at fault, neither could get a divorce. If Frank cheated on Eleanor, but Eleanor had also been caught in a lie or had been seen with another man, the judge would rule that since both had unclean hands, the marriage must continue. It was a form of state-mandated punishment. The law essentially said that if you are both bad spouses, you deserve each other, and the state will not help you part ways. This led to a toxic cycle where spouses would spend thousands of dollars on investigators just to prove the other was just as bad as they were, effectively trapping both in a stalemate of misery. As the decade hit its midpoint, the psychological toll on children became a central part of the national conversation. The 1960s was the era of the broken home. This term carried a weight of shame that is hard to imagine in 2026. Children of divorced parents were often treated as social outcasts or seen as being at a permanent psychological disadvantage. Teachers, neighbors, and even doctors would point to a divorce as the root cause of any behavioral issue, from poor grades to a common cold. This social pressure acted as a secondary cage. Parents were told by every magazine and talk show that staying together for the sake of the kids was the only moral choice, even if the home environment was a war zone. However, by 1967, the cracks in this philosophy were becoming visible. A new wave of sociologists began to argue that a high-conflict marriage was actually more damaging to a child than a stable, single-parent home. This was a radical idea that began to shift the permission structure of American society. People started to realize that the traditional nuclear family was not a one-size-fits-all solution for human happiness. This brings us to the pivotal year of 1969, where the legal, social, and economic pressures finally forced a total collapse of the old system. The transition from the adversarial model to the no-fault model wasn't just a change in the law. It was a change in the American soul. It was the moment the United States decided that the pursuit of happiness was not just a political slogan, but a domestic right. But as the doors were finally thrown open, no one was prepared for the flood that was about to follow. The legal systems were built for a slow trickle of cases, but they were about to be hit by a tidal wave that would redefine gender roles, wealth distribution, and the very meaning of the word family. In the next part, we are going deep into the specific mechanics of the 1969 California no-fault revolution. We will look at how Ronald Reagan, a man who built his career on traditional values, became the architect of the greatest shift in matrimonial history. We will also explore the immediate and shocking consequences of that law, including a case study of a town where the divorce rate tripled in a single month. What happens when you tell a generation of people they are finally free to leave? The answer is more complicated than anyone expected. The year was 1969, and the cultural landscape of the United States was a swirling vortex of change. But while the nation's eyes were fixed on the Apollo 11 moon landing and the mud-soaked fields of Woodstock, a far more quiet but consequential revolution was taking place in the office of the governor of California. Ronald Reagan, a man who would eventually be remembered as the champion of traditional American values, sat at his desk and put his pen to a document that would fundamentally alter the DNA of the American family. This document was the Family Law Act of 1969. To understand the gravity of this moment, we have to look at the man himself. Reagan was the only United States president to have been divorced, having ended his marriage to actress Jane Wyman years earlier. He knew firsthand the messy, public, and often humiliating process of an adversarial divorce. He believed that by signing this act, he was bringing dignity back to a broken process. He thought he was simply removing the incentive for spouses to lie, cheat, and commit perjury just to gain their freedom. Historical trends show that Reagan later looked back on this decision with a profound sense of regret, calling it one of the greatest mistakes of his political career. But in 1969, the momentum was unstoppable. The law, which officially took effect on January 1, 1970, introduced the concept of no-fault divorce to the Western world. It replaced the word divorce with the softer, more clinical term dissolution. More importantly, it removed the requirement to prove a specific wrong. No longer did you need a private investigator to capture a grainy photograph of a cheating spouse. No longer did you have to testify that your partner was a monster. You simply had to state that the marriage suffered from irreconcilable differences which have caused the irremediable breakdown of the marriage. Imagine if you were a citizen in 2026 looking back at the mechanics of this shift. In the pre-1969 era, if a husband and wife both wanted to leave but neither had committed a crime like adultery or physical abuse, they were effectively stuck. This led to the clean hands doctrine, a legal principle that stated if both parties were at fault, neither could be granted relief. It was a judicial stalemate that kept miserable people tethered together as a form of state-sanctioned punishment. The 1969 Act didn't just open a door, it took the hinges off. It allowed for unilateral divorce, meaning one person could decide the marriage was over, and the other person had no legal power to stop it. This was a radical departure from the idea of marriage as a binding contract that required mutual consent or a significant breach to dissolve. Step by step, the process changed overnight. Before the act, a divorce trial was a theater of the macabre. Lawyers would coach witnesses to exaggerate claims of mental cruelty. Husbands would intentionally get caught in staged infidelities. After the act, the courtroom became a place of administrative math. The focus shifted almost entirely from why the marriage ended to how the assets would be split. This is where we see the emergence of the community property standard in its most modern form. In California, this meant that everything acquired during the marriage was split exactly 50-50. On paper, this sounds like the pinnacle of fairness. However, the case studies from the early 1970s reveal a much darker economic reality for women. Consider a character named Linda, a composite of the thousands of women who navigated this transition. In 1969, Linda is 45 years old. She has spent 20 years as a dedicated homemaker, supporting her husband's career, raising 3 children, and managing a household. She has no professional network, no recent work experience, and no independent retirement savings. Under the old fault-based system, if her husband left her for a younger woman, the court would often use alimony as a way to punish the husband's bad behavior and provide Linda with a lifestyle similar to what she had during the marriage. Alimony was essentially a lifelong pension for the innocent party. But under the new no-fault system, the moral compass was removed from the courtroom. The judge no longer cared that the husband was the one who broke the vows. The community property rule meant that the house was sold, the assets were split, and Linda was expected to become self-sufficient as quickly as possible. This led to what sociologists later termed the feminization of poverty. While the husband's standard of living often rose after a divorce because his earning power remained intact and he no longer had to support a full household, the wife's standard of living frequently plummeted. Data from the decade following the California experiment suggests that women's standard of living dropped by an average of 73% after divorce, while men's increased by 42%. The ripple effect across the United States was instantaneous. Although California was the first, other states watched the experiment with intense interest. They saw the divorce rate in California jump by nearly 50% in the first year alone. This wasn't because people suddenly became unhappier. It was because the legal barrier to exit had been lowered to the floor. There was a backlog of decades of misery that was suddenly being processed through the courts. This created a cultural shockwave that hit the heartland. In small towns across America, the sight of a moving truck at a neighbor's house became a frequent and unsettling occurrence. The potential outcomes of this legal shift weren't just economic or legal. They were deeply psychological. For the first time in American history, the idea of a permanent marriage became an aspirational goal rather than a legal certainty. This changed the way people entered into marriages in the late 1960s. The stakes were lower, but the anxiety was higher. We began to see the rise of the prenuptial agreement, though it was still in its infancy and carried a heavy social stigma. People were starting to realize that the state was no longer in the business of enforcing the till death do us part clause of their vows. As we analyze this from our vantage point in 2026, we can see that the 1969 California law was the catalyst for the modern domestic landscape. It moved the United States from a society based on institutional duty to a society based on individual fulfillment. But this freedom came with a massive, uncalculated cost to the social fabric. The 1960s began with the image of the perfect nuclear family and ended with a legal framework that made that family more fragile than it had ever been. The sheer volume of cases began to overwhelm the judicial system. Judges who were used to spending days on a single complex divorce trial were now processing dozens of dissolutions in a single afternoon. The human element was being stripped away, replaced by a bureaucratic machine. This led to a sense of coldness and alienation for those going through the process. They were no longer victims or defendants. They were petitioners and respondents in a standardized legal transaction. But as the 1960s closed and the 1970s began, a new and even more complex problem emerged. While the parents were busy navigating their newfound freedom and the economic fallout of the no-fault revolution, an entire generation of children was caught in the crossfire. The 1960s gave parents the right to leave, but it didn't provide a manual for what to do with the children who were left behind in the wreckage of the broken home. In the next part, we are going to dive into the forgotten victims of the 1960s divorce revolution, the children. We will look at the rise of the visitation schedule, the psychological studies that claimed divorce was a victimless crime, and the shocking data that would eventually debunk those theories decades later. We will also explore how the 1960s shift in marriage laws paved the way for the radical gender role reversals of the 1970s. What happens to a child's worldview when the most stable foundation in their life suddenly turns into a legal negotiation? The answer changed the trajectory of an entire generation. Imagine a second grader named Bobby sitting in a wood-paneled classroom in 1967. The teacher asks the students to draw a picture of their family sitting around the dinner table. For most of his peers, the drawing is predictable: a mother in a floral apron, a father in a suit or work blues, and a couple of siblings. But Bobby hesitates. His father hasn't lived in the house for 6 months. In 1967, Bobby is a pioneer of a new uncomfortable social category: the child of a broken home. This phrase, which feels archaic and harsh in 2026, was the standard clinical and social descriptor for Bobby's reality. It didn't just describe a change in address. It carried a heavy implication of structural failure. To the educators and psychologists of the mid-1960s, Bobby wasn't just a kid whose parents didn't get along. He was a potential outcome of a societal breakdown, a child who many feared would grow up without a moral compass or a sense of stability. Historical trends during this specific window of the 1960s show a massive conflict between old-world legal doctrines and new-world psychological theories. The primary legal framework governing Bobby's life was the tender years doctrine. This was a judicial presumption that during a child's tender years, generally defined as under the age of 7 or 13, the mother was the only suitable custodian unless she was proven to be morally unfit. This meant that in 1965, custody wasn't really a negotiation. It was a foregone conclusion. Fathers were relegated to the role of the visitor. This era saw the birth of the every other weekend father, a social phenomenon that would define the American male experience for decades. Imagine if your entire relationship with your primary male role model was compressed into 4 days a month, usually involving trips to the cinema, the zoo, or a greasy diner because the father's new bachelor apartment wasn't equipped for a child's daily life. As we analyze this from 2026, we see that the 1960s was the decade where the logistical blueprint for modern divorce was drafted. The visitation schedule was a radical invention. Before the mid-60s, if a marriage ended, it was often so high conflict that one parent, usually the father, simply vanished from the child's life entirely. But the mid-60s introduced the idea of the civilized divorce, where the father remained a presence, albeit a marginalized one. This created a new type of psychological pressure called the loyalty conflict. Bobby had to navigate two different worlds. His mother's home, where the father's name was often spoken with a mix of resentment and silence, and his father's weekend world, which felt like a perpetual vacation that lacked any real discipline or domesticity. This brings us to a massive case study in social engineering, the victimless crime theory of divorce. In the late 1960s, a new wave of child psychologists began to challenge the traditional view that divorce was a catastrophe for children. They argued that kids are resilient, and that it was far better for a child to live in a peaceful single-parent home than in a high-conflict two-parent home. While this sounded compassionate and logical, it was often used as a convenient justification for adults to pursue their own fulfillment without considering the long-term data. At the time, there were no long-term longitudinal studies on the children of divorce. The experts were guessing. They were providing a permission structure for a generation of parents who felt trapped. Step by step, the 1960s dismantled the protective stigma that kept parents together. By 1968, the idea that a child could actually benefit from their parents' divorce was being discussed in mainstream magazines like Look and Life. This was a total reversal from the beginning of the decade, when a divorced mother was seen as a tragic figure and her children were viewed with pity by the local PTA. But the economic data for children like Bobby told a different story. When a household split in 1969, the child's standard of living almost always dropped. In an era before automated child support withholding or the robust enforcement we have in 2026, many fathers simply stopped paying. There were no digital footprints to track a deadbeat dad across state lines. If a father moved from Ohio to California and stopped sending checks, the mother and child were often left to fend for themselves. This led to the rise of the latchkey kid, a term that started to gain traction as mothers were forced into the workforce out of sheer necessity. Imagine Bobby coming home to an empty house at 3:30 p.m. because his mother is working a secretarial job to make up for the missing child support. He has a key around his neck and instructions not to answer the door. This wasn't a sign of independence. It was a symptom of the economic instability that followed the 1960s divorce surge. The potential outcomes for these children were significant. We began to see higher rates of school absenteeism and lower academic performance among children of broken homes, compared to their peers in intact families. But there is another layer to this deep dive: the racial and class disparities in how 1960s divorce affected children. For white middle-class families, divorce was a tragedy to be managed. But for minority communities, particularly black families in urban centers, the 1965 Moynihan Report, officially titled The Negro Family, The Case for National Action, ignited a firestorm of controversy. The report argued that the breakdown of the nuclear family structure was the primary driver of poverty and social instability. While the report was criticized for being paternalistic and ignoring systemic racism, it highlighted a cold reality. The divorce and abandonment trends of the 1960s hit vulnerable communities the hardest, as they lacked the generational wealth or social safety nets to cushion the blow. By 1969, the 1960s had effectively turned the American child into a legal commodity. The best interests of the child standard began to replace the tender years doctrine in some progressive courts. This sounded like a win for children, but in practice, it meant that judges had more power to decide a child's fate based on their own personal biases. A judge could decide that a mother was unfit because she was part of the counterculture movement or because she worked too many hours. The child's life became a pawn in a larger cultural war between traditionalism and the new age of autonomy. We have to ask, was the freedom of the parents worth the instability of the children? In 2026, we are still analyzing the intergenerational transmission of divorce. The children of the 1960s were the first generation to see that marriage was optional, and when they grew up, they divorced at even higher rates than their parents. The 1960s didn't just change the laws, it changed the internal hardware of how Americans viewed commitment. But as we look at the end of the 1960s, another massive shift was occurring. It wasn't just about the law or the kids. It was about the way the media began to sell the glamour of the single life. The 1960s started with Father Knows Best and ended with a new kind of celebrity: the glamorous independent divorcee. This media shift would create a false sense of security that would lead millions into a legal and financial maze they weren't prepared for. In the next part, we are going to explore the Hollywood effect. We will look at how movies like The Parent Trap and magazines like Cosmopolitan reframed divorce as an adventurous new beginning, rather than a domestic failure. We will also dive into the case studies of the first celebrity mega-divorces of the 1960s that turned private heartbreak into public entertainment. What happens when the most private pain in a person's life becomes a script for the rest of the country to follow? The answer involves a massive industry that was built on the ruins of the American living room. By 1961, the American living room was no longer just a place for family dinners. It was a front-row seat to the dismantling of the traditional domestic ideal. If you were a moviegoer in 1961, you likely saw The Parent Trap. In this Disney classic, twin sisters separated by their parents' divorce hatch a scheme to reunite them. While the film is a lighthearted comedy, it served as a massive cultural touchstone that reflected a deep-seated national anxiety. It suggested that a broken home was a problem that could be solved with enough pluck and a bit of teenage matchmaking. But for the millions of children actually living through the 1960s divorce surge, the reality was far less cinematic. The film normalized the concept of the split household for a mainstream audience, but it also fueled a fantasy of reconciliation that rarely manifested in the historical trends of the era. While Disney was sanitizing the experience for children, adult cinema was taking a much darker, more honest look at the crumbling of the American marriage. Consider the 1961 film The Misfits, starring Marilyn Monroe and Clark Gable. The movie begins with Monroe's character in Reno, Nevada, finishing her 6-week residency to obtain a quick divorce. This film didn't treat divorce as a joke or a mistake to be corrected. It treated it as a profound existential crisis. It showed the world that Reno wasn't just a legal loophole. It was a purgatory for the disillusioned. For the first time, audiences were seeing the emotional fallout of the migratory divorce, the loneliness of the boarding house, the transactional nature of the legal process, and the sense of being cast adrift in a society that still didn't quite know where to put a single woman. Imagine if you were a housewife in 1965, living in a community where divorce was still spoken about in hushed tones. You pick up a copy of Cosmopolitan magazine. In 1965, Helen Gurley Brown took over as editor-in-chief and began an aggressive rebranding of the American woman. She introduced the concept of the Cosmo Girl, independent, sexual, and unapologetically focused on her own career and pleasure. This was a direct assault on the 1950s ideal of the self-sacrificing mother. Brown's editorial vision reframed the divorcee not as a failure, but as a woman of experience. She was someone who had been through the fire and come out more interesting, more capable, and more desirable. This media shift created a potential outcome that many women hadn't considered: that life after divorce could actually be better than the marriage itself. However, this glamorous media portrayal often collided violently with the economic reality. Step by step, the media was building a bridge to a new lifestyle that the legal and financial systems weren't ready to support. While magazines were telling women they could have it all, the banks were still refusing to give them a line of credit without a husband's signature. This created a profound sense of cognitive dissonance. You could see the liberated life on your television screen, but you couldn't afford it in your neighborhood. Case studies of suburban women in the mid-1960s show a recurring pattern. They would follow the cultural cues to seek independence, only to find themselves trapped in a secondary cage of financial dependency on an ex-husband who might or might not send a check on the first of the month. The 1960s also saw the birth of the celebrity megadivorce as a form of national entertainment. The most prominent example was the ongoing saga of Elizabeth Taylor and Richard Burton. Their relationship was a whirlwind of expensive jewelry, international travel, and explosive public fights. When they married and divorced and then married and divorced again, it was front-page news. This transformed the private pain of a failing marriage into a spectator sport. It taught the American public that marriage was a high-stakes drama that could be cast and recast as often as necessary. This celebrity influence cannot be overstated. It provided a level of social cover for the average citizen. If the most famous woman in the world could have 4 or 5 husbands, then surely a schoolteacher in Ohio could have 2. But as the media began to sell the idea of the fresh start, a massive new industry began to take root: the divorce industrial complex. Before the 1960s, divorce lawyers were often viewed as the bottom feeders of the legal profession. They dealt with the mess and the shame that respectable corporate firms wouldn't touch. But as the divorce rate climbed, the profitability of domestic law skyrocketed. Lawyers became the new rock stars of the legal world, specializing in high-stakes asset division. We began to see the rise of the divorce manual and the self-help book. In 1967, titles began appearing on bookstore shelves that offered step-by-step instructions on how to survive the legal process and the social transition. This was the first time that the end of a marriage was treated as a consumer experience that required professional management. In 2026, we might look back and see these media artifacts as quaint, but in 1966 they were revolutionary. They were providing a script for a play that millions of Americans were being forced to perform without any rehearsal. Imagine a character named Kathy. She is 32, lives in a quiet town in Indiana, and has decided to leave her husband after reading an article about personal growth. She expects the world to look like a Doris Day movie once she gets her decree. She expects to find a vibrant community of single people and a rewarding career. Instead, she finds that her married friends stop inviting her to dinner because they don't know how to talk to a single woman. She finds that her local grocer looks at her with a mix of pity and suspicion when she asks for a store account in her own name. The Hollywood effect had promised her a glamorous new beginning, but the 1960s infrastructure only offered her a cold, uphill climb. The media also began to play a role in the political pressure for no-fault laws. Talk shows in the late 1960s started featuring segments on the absurdity of the current system. They would bring on couples who had gone through the hotel room photo scam in New York, exposing the legal system as a farce. This public shaming of the law was a critical component in building the consensus for reform. The media didn't just reflect the change, it actively campaigned for it. By the time 1969 arrived, the American public had been conditioned by a decade of films, magazines, and celebrity gossip to believe that the old ways were not just outdated, but morally bankrupt. But there was one institution that was not ready to surrender to the Hollywood version of the American family: the church. As the media was pushing for more freedom and less stigma, the religious foundations of the country were preparing for a counterattack. The conflict between the pulpit and the press would define the closing years of the decade and set the stage for the massive cultural divide that still exists in 2026. In the next part, we are going to dive into the religious war over divorce in the 1960s. We will look at how the Catholic Church and various Protestant denominations fought to keep the legal barriers in place, and the internal revolts that occurred when their own congregations began to ignore the doctrine. We will also explore the case study of the first clergy members who began to perform remarriage ceremonies, effectively breaking a centuries-old taboo. What happens when the law says yes, the media says yes, but the person in the pulpit says no? The answer involves a theological earthquake that would forever change the landscape of American faith and family. To understand the religious landscape of 1960, you have to imagine a world where the local pastor, priest, or rabbi held more sway over a family's social survival than any judge or politician. In 1962, the church was not just a place of worship, it was the ultimate moral gatekeeper. If you were a member of a community like the one inhabited by a character we will call Mary, a devout mother in a tight-knit Catholic parish in Boston, the concept of divorce was not just a legal impossibility, it was a spiritual death sentence. In Mary's world, the marriage bond was viewed as a sacrament that was inherently indissoluble. The phrase "what God has joined, let no man put asunder" was not a suggestion. It was the bedrock of her entire social and spiritual identity. Case studies from the early 1960s show that for many Catholics, the only available exit was an annulment, which was a complex and often prohibitively expensive legal process within the church to prove that a valid marriage never existed in the first place. This usually required proving something like a lack of intent to procreate or a hidden psychological defect at the time of the vows. If Mary couldn't get an annulment and chose to divorce anyway, she faced excommunication. In 1963, this meant she could no longer receive the Eucharist, her children might be treated differently in parochial school, and her own parents might be pressured by the community to distance themselves from her. This social shunning was a powerful deterrent that kept thousands of miserable couples together. However, historical trends show that by 1965, the ground began to shift beneath the pews. The Second Vatican Council, or Vatican II, which took place from 1962 to 1965, was intended to open the windows of the church to the modern world. While the official doctrine on divorce did not change, the tone of the church did. Documents like Gaudium et Spes began to emphasize the dignity of the human person and the importance of a community of love within marriage, rather than just a legalistic contract for procreation. This created a subtle but significant opening. Imagine if you were a parishioner listening to a younger, more progressive priest in 1966 who started talking about the importance of mental health and personal fulfillment. For the first time, people like Mary felt they had a theological inch to explore their own unhappiness. Within Protestant denominations, the conflict was equally intense but manifested differently. In 1960, most mainline Protestant churches, Methodists, Presbyterians, and Episcopalians, held a standard that followed the adultery exception. This meant a divorce was only morally permissible if one spouse had been unfaithful. But as the 1960s progressed, these denominations began to experience an internal revolt from the laity. People were looking at the potential outcomes of their lives and realizing that the traditional rules were causing immense suffering. Step by step, these churches began to adopt a more therapeutic model of ministry. By 1967, many mainline churches had moved toward a position of compassionate ministry, where divorce was viewed as a tragic, but sometimes necessary solution to a broken relationship. This shift was not universal. In the Southern Baptist Convention and other evangelical circles, the 1960s was a period of doubling down on traditionalist views. This created the first major cracks in what we now recognize in 2026 as the Great American Cultural Divide. Imagine a character named John, a deacon in a conservative church in rural Georgia in 1968. When his neighbor, a fellow church member, decided to leave his wife without a scriptural reason, John didn't just see a family breaking up. He saw a frontal assault on the Word of God. This era saw the birth of the modern pro-family political movement, as religious leaders began to realize that their moral authority was being bypassed by a secular legal system that was rapidly moving toward no-fault standards. The year 1966 was a pivotal moment in this religious war because of the release of the Masters and Johnson study on human sexual response. This scientific deep dive into pleasure and intimacy forced religious institutions to confront the fact that marriage was increasingly being viewed through the lens of sexual and emotional satisfaction, rather than just duty and lineage. If a marriage failed to deliver on these new, high-stakes expectations of intimacy, the religious argument for staying together became harder to sell to a generation that was being told by every other sector of society to follow their bliss. As the decade hit its closing years, the tension between the law and the pulpit reached a fever pitch. When California passed the no-fault law in 1969, it felt like a declaration of war for many religious conservatives. They argued that the state was essentially abdicating its responsibility to protect the family. They feared that if the state stopped caring about fault, the moral fabric of the country would unravel. But the reality on the ground was that many churchgoers were already voting with their feet. The data shows that divorce rates among religious Americans began to climb in tandem with the rest of the country, proving that not even the threat of eternal damnation could compete with the mid-century drive for individual autonomy. Consider the scenario of the first church-sanctioned remarriages for divorced individuals. In 1960, most churches would refuse to perform a wedding for someone who had a living ex-spouse. But by 1969, a growing number of clergy members began to perform these ceremonies, often in small, private settings or in the basements of more liberal parishes. This was a radical act of rebellion that signaled the church's loss of control over the marriage market. The religious institution was being demoted from the primary decider of a marriage's validity to a secondary provider of social blessing. This theological earthquake also forced a re-examination of the role of women within the church. As more women sought divorces to escape domestic stagnation or abuse, they began to question why the church's leadership was exclusively male. The 1960s divorce revolution was a primary driver for the burgeoning movement for women's ordination in the 1970s. Women like Mary realized that they could not trust a male-dominated hierarchy to understand the nuances of their domestic lives. They wanted a seat at the table where the rules were made. By 1970, the battle was largely won by the secularists in the legal and cultural spheres, but the religious scars remained. The 1960s created a new kind of religious experience in America: the divorced and remarried believer who had to find a way to reconcile their personal history with their faith. It led to the rise of specialized ministries and support groups within churches, changing the church from a fortress of perfection into a hospital for the brokenhearted. But this transition was anything but smooth. What happens to a society when its two most powerful institutions, the law and the church, suddenly stop speaking the same language? The result was a vacuum of authority that was quickly filled by a group of people who saw a massive opportunity for profit. While the priests and the judges were arguing over morality and logic, a new class of professionals was sharpening their knives to slice up the American family's assets. In the next part, we are going to look at the rise of the divorce predator. We will go deep into the history of the 1960s divorce lawyers, who became famous for their scorched earth tactics. We will look at how the shift from fault to no fault actually made legal fees explode rather than decrease. We will explore the case study of a celebrity lawyer who managed to turn a simple split into a 3-year multi-million-dollar war. What happens when the person who is supposed to help you move on actually has a financial incentive to keep you fighting? The answer involves a dark side of the legal profession that still haunts our courtrooms in 2026. The transition from the adversarial fault system to the no-fault era in the late 1960s was pitched to the American public as a way to reduce conflict, lower costs, and bring a measure of peace to the end of a marriage. But for many, the reality was a brutal bait-and-switch. In 2026, we are well aware of the high costs of legal battles, but in 1968, the explosion of the divorce industry was a shocking new phenomenon. If you were a high-earning professional in 1969, call him David, a successful architect in Los Angeles, you might have thought that the new laws would make your split from your wife, Sarah, a simple administrative matter. Instead, David and Sarah found themselves at the center of a new kind of battlefield. The war was no longer about who slept with whom. It was about the cold, hard valuation of every single thing they owned. This was the birth of the divorce predator. Before this shift, legal fees were relatively predictable because the grounds for divorce were often binary. You either had the photograph of the infidelity or you didn't. But with the advent of community property and the 50-50 split, the incentive for lawyers shifted from proving a moral wrong to conducting a forensic search for every hidden asset. This created a step-by-step escalation in legal tactics that we still see in our courtrooms today. Step 1 was the filing of the petition, which now required a comprehensive financial disclosure. In the early 1960s, these disclosures were often rudimentary. By 1969, they became exhaustive documents that served as a roadmap for litigation. Step 2 was the discovery phase. This is where the 1960s divorce lawyer truly earned the title of predator. Lawyers realized that the more they could complicate the valuation of an asset, the more hours they could bill. Imagine if David owned a share in an architectural firm. Under the old system, the firm might not even be on the table. Under the new 1969 California rules, Sarah's lawyer would argue that her years of social entertaining and domestic support contributed to the firm's goodwill value. This led to the rise of the forensic accountant as a staple of the divorce process. Historical trends show that the late 1960s saw a massive spike in the employment of third-party experts. It wasn't just about the house and the car anymore. It was about the pension, the stock options, and the projected future earnings. For a character like David, this meant that a process he expected to take 6 months and cost a few $1,000s turned into a 3-year odyssey that consumed 30% of his net worth in legal and expert fees. The lawyers weren't just representatives. They were the primary beneficiaries of the marital estate's dissolution. Case studies from the late 1960s highlight the emergence of the celebrity divorce lawyer. Men like Marvin Mitchelson, who would later become famous for the concept of palimony. These attorneys understood that the new laws didn't actually end the adversarial nature of divorce. They just changed the currency. If you couldn't use a spouse's fault to get a better settlement, you used discovery to bury them in paperwork until they settled out of sheer exhaustion. This was psychological warfare disguised as accounting. The potential outcomes for a client were often dictated not by the law, but by the size of their legal war chest. If one side could afford to keep the discovery process going for years, the other side was often forced to accept an unfair settlement just to survive financially. Imagine if you were Sarah in this scenario. You have been told that you are entitled to half of everything. But David's lawyer has structured his assets in a way that makes them look worthless on paper. You have to hire your own team of experts to peel back the layers of his business interests. By 1969, the 50-50 rule, which was designed to protect women, often became a trap. Because the law no longer cared about the husband's fault, a woman who had been cheated on or abandoned lost the leverage she once had to demand a larger share of the assets as a form of reparations. She was now in a math fight with a man who usually had more control over the family's finances. This professionalization of conflict created a new social class, the divorce-wealthy attorney. In 1960, a lawyer who did divorces was often at the bottom of the firm hierarchy. By 1970, they were the ones driving the newest Cadillacs and buying homes in Beverly Hills. They had successfully rebranded a social tragedy into a lucrative business model. They marketed themselves as protectors of your future, but their financial incentive was to keep the embers of resentment burning. Every phone call, every angry letter sent to the opposing counsel, And every motion for a new hearing was another $100 in the lawyer's pocket. The data from the end of the decade shows a disturbing trend. As the number of divorces rose, the time it took to finalize a divorce also increased in high-asset cases. The courts were becoming clogged not just with the volume of people, but with the complexity of their arguments. Judges who were once moral arbiters were now being forced to act as amateur accountants and business valuators. They were overwhelmed and often ill-equipped for the task, which led to inconsistent rulings and even more appeals, further enriching the legal profession. But perhaps the most insidious part of the divorce predator's strategy was the use of the children as a financial lever. While the laws were changing regarding assets, the custody laws were still in a state of flux. Lawyers in the late 1960s began to realize that fighting for custody wasn't just about the kids. It was about the child support and the right to stay in the family home. They would encourage their clients to use the children as pawns to get a better deal on the vacation house or the retirement fund. This turned the 1960s divorce into a holistic war where no part of a person's life was off limits. As we look back from 2026, we can see that the 1960s didn't just liberate Americans from bad marriages. It birthed an industry that depends on the failure of those marriages to thrive. The 1960s divorce lawyer taught the country that the end of a relationship was not just a personal failure, but a commercial opportunity. They created a blueprint for litigation that ensures, even today, that the only certain winners in a divorce are the people in the suits. But even as the lawyers were counting their fees, another movement was beginning to brew in the background. A group of people was looking at the wreckage of the American family and the greed of the legal system and saying, there has to be a better way. They were the pioneers of the self-help movement, the mediation advocates, and the ones who believed that you didn't need a shark to get through a storm. However, this new movement would bring its own set of complications and unintended consequences that would further blur the lines of the American domestic identity. In the next part, we are going to explore the rise of the divorce DIY movement. We will look at the 1960s activists who began publishing kits on how to divorce without a lawyer, the legal establishment's furious attempt to ban those kits, and the case study of a woman who took her own divorce all the way to the Supreme Court to prove that freedom shouldn't have a cover charge. What happens when the public decides they don't need the experts anymore? The answer involves a total collapse of professional gatekeeping that would change the middle class forever. Imagine a woman named Susan in 1968, sitting at her kitchen table in a small apartment in Hartford, Connecticut. Susan has been separated from her husband for 2 years. He has moved to another state, provides no support, and she is raising 2 toddlers on a meager welfare check. Susan wants a divorce to legally close this chapter of her life, and perhaps marry a man who actually wants to be a father to her children. She goes to a private law firm and is told the retainer is $500. In 1968, that is equivalent to several months of her total income. She goes to a legal aid clinic, but they are so overwhelmed with criminal cases and housing disputes that they tell her a simple divorce is not a priority. Susan is stuck. She is legally bound to a ghost because she cannot afford the entrance fee to the American judicial system. This was the reality for thousands of Americans as the 1960s came to a close. The law said they had the right to leave, but the gatekeepers said they had to pay a toll they couldn't afford. This frustration gave birth to the divorce DIY movement, a grassroots rebellion that would eventually strip the legal profession of its monopoly on domestic freedom. It began with a few brave souls and a manual typewriter. In the late 1960s, legal activists began to realize that the paperwork for a simple, uncontested divorce was not actually complex. It was a series of standardized forms: the summons, the petition for dissolution, the financial affidavit, and the final decree. The only reason it required an expensive lawyer was because the bar associations had successfully lobbied for laws against the unauthorized practice of law. If a non-lawyer gave you a form and told you where to sign, they could be thrown in jail. Step by step, the resistance began to form. One of the most significant figures in this shift was a man named Ed Sherman, a Berkeley-educated lawyer who grew tired of the gatekeeping. In the late 1960s, he began drafting what would become the first comprehensive DIY divorce kit. He didn't just provide the forms, he provided a roadmap. He explained the jargon. He told people that they didn't need to be afraid of the judge. Imagine the scandal this caused in 1969. To the legal establishment, Sherman was a traitor. They argued that divorce was too delicate a matter for the layperson to handle. They claimed that without a lawyer, people would make mistakes with their property or their children that would haunt them for decades. Historical trends show that while the bar associations framed their opposition as public protection, it was clearly about market protection. The 1960s had turned divorce into a cash cow for mid-sized firms, and they were not about to let a $25 kit take that away. Case studies from this era show that bar associations across the country began filing lawsuits against anyone who sold these kits. They used the police to raid small print shops and bookstalls. They treated a packet of legal forms like it was contraband. But the more they pushed back, the more the public realized that they were being overcharged for what was essentially clerical work. This conflict reached its peak in the case of Gladys Boddy. Gladys was a welfare recipient in Connecticut. Much like our character Susan, she wanted a divorce but couldn't afford the $60 court filing fee, let alone a lawyer. In 1968, her case began working its way through the system. Her argument was simple and revolutionary. If the state requires a legal process to end a marriage, then the state cannot deny that process to people simply because they are poor. This was a direct challenge to the idea that the courtroom was a private club. While the Supreme Court wouldn't rule on Boddy versus Connecticut until 1971, the legal battle throughout 1969 became a rallying cry for the DIY movement. It highlighted the absurdity of a system that preached the sanctity of the family, while simultaneously charging a cover charge to leave a broken one. The potential outcomes of this DIY movement were transformative for the American middle class. It wasn't just about the very poor. It was about the millions of people who had a little bit of money but didn't want to hand it all over to a lawyer for a process where there was nothing to fight about. Imagine a couple who has been married for 3 years, has no kids, and rents an apartment. Under the old system, they still had to hire 2 lawyers and go through the adversarial theater. With the DIY movement, they could sit down at their kitchen table, fill out the forms themselves, and file them at the courthouse for the cost of a few movie tickets. This effectively democratized divorce. However, the 1960s DIY movement also introduced a new set of risks. Because people were handling their own cases, they often missed the fine print regarding future rights. A woman might get her quick divorce in 1969 using a kit, but failed to realize she had waived her right to a portion of her husband's Social Security or pension decades down the line. The legal establishment used these errors as proof that the DIY movement was dangerous. But the public didn't care. The desire for immediate freedom outweighed the concern for long-term financial planning. The 1960s had fostered a culture of the now, and that applied to the end of marriages as much as it did to music or politics. By the end of 1969, the DIY movement had forced a fundamental shift in how the courts operated. Clerks at courthouses who were used to only dealing with suits and ties were now being confronted by ordinary citizens clutching pamphlets and hand-filled forms. This forced the courts to simplify their own procedures. They had to create pro-se departments to help people navigate the bureaucracy. The gate was being kicked open, and the lawyers were being forced to justify their high fees by taking on only the most complex cases, rather than the easy administrative ones. In 2026, we see the legacy of this movement in every online legal service and every state-sponsored self-help portal. But in 1969, it was an act of civil disobedience. It was the moment the American public decided that their personal lives were their own business, not the business of a legal guild. This collapse of gatekeeping was a necessary step in the 1960s revolution, but it also contributed to the sense that marriage was no longer a profound, lifelong covenant, but rather a temporary contract that could be canceled as easily as a magazine subscription. As the decade closed, the United States was standing on the edge of a domestic cliff. The laws had changed, the church had lost its grip, the media had sold a dream of independence, and the DIY movement had made the exit affordable. Everything was in place for a total explosion of the American family structure. But there was one final ingredient that would turn the steady climb of the 1960s divorce rate into the vertical spike of the 1970s. It wasn't a law, a book, or a movie. It was a change in the way men and women actually spoke to each other, or stopped speaking to each other. In the next part, we are going into the psychological shift of the late 1960s, the rise of the communication gap. We will look at how the terminology of therapy, words like space, needs, and validation, became the new weapons used in marital arguments. We will explore the case study of the first marriage encounters, and how they often backfired, leading couples directly from the therapy couch to the courthouse. What happens when you teach a generation that their primary obligation is to their own mental health? The answer is the decade of the me, and the total redesign of the American heart. By 1969, the American heart was no longer being governed by the old rules of endurance and duty. It was being re-engineered by a new seductive vocabulary of self-actualization. To understand this, we have to look at the human potential movement, which swept through the United States in the late 1960s like a psychological wildfire. Imagine a man named Mark, a typical white-collar employee in 1960. Mark's father had taught him that a successful life was measured by stability. You keep your job, you provide for your family, and you stay married regardless of your internal state of mind. But by 1968, Mark is sitting in a living room in a suburb of Seattle, listening to a neighbor talk about a weekend retreat at the Esalen Institute in California. He is being introduced to the idea that his primary obligation is not to his wife, Nancy, or his children, but to his own personal growth. This was a seismic shift in the hierarchy of needs. In 1960, most Americans were still operating under a survival or security mindset. If the bills were paid and the kids were healthy, the marriage was considered a success. But as the 1960s progressed, the psychological theories of men like Abraham Maslow began to trickle down into the mainstream. Maslow's hierarchy of needs suggested that once basic safety was secured, the ultimate human goal was self-actualization, the realization of one's full potential. For many couples like Mark and Nancy, this created a new impossible standard for marriage. It was no longer enough to be a good provider or a diligent homemaker. You had to be a soulmate, a co-explorer of the psyche, and a constant source of emotional validation. Step by step, the language used inside the American home began to change. Words like compatibility, space, and finding myself replaced older terms like sacrifice, commitment, and for the children. This therapeutic jargon provided a sophisticated cover for a deep-seated restlessness. Historical trends show that by 1967, the sale of psychology books for the layperson had skyrocketed. People were looking for permission to be unhappy. They were being told that staying in a stagnant marriage was not a virtue, but a form of psychological suicide. This created what sociologists call the expressive individualist model of marriage. In this model, the relationship is only as good as the personal satisfaction it provides to each individual at any given moment. Imagine the scenario of a 1968 dinner party where the conversation turns to the idea of a trial separation. In 1960, such a suggestion would have been met with shocked silence. By 1968, it was discussed as a proactive step toward mental health. This era saw the rise of the communication gap as a standard diagnosis for marital failure. The logic was that if couples could just talk more, express their feelings more, and be more vulnerable, they could save their relationships. This led to the birth of the marriage encounter movement. Originally started within the Catholic Church, these were intensive weekend retreats designed to help couples communicate, shutterstock, explore. However, the case studies of these encounters reveal a fascinating irony. For many couples, the act of radical honesty didn't bring them closer together. It simply provided the clarity they needed to realize they were fundamentally incompatible. By forcing people to voice their deepest dissatisfactions, these retreats often acted as an accelerant for divorce, rather than a preventative. Mark and Nancy might go into a weekend retreat hoping to rekindle their romance, only to spend 48 hours discovering that Mark wanted a life of adventure, while Nancy wanted a life of quiet security. The communication gap was bridged, but only to reveal an uncrossable canyon. The 1960s also saw the psychological decoupling of the husband and wife roles. We have to look at the impact of consciousness-raising groups on women's psychological readiness for divorce. In the late 1960s, women began meeting in small groups to discuss their lives not as wives or mothers, but as individuals. They realized that their feelings of depression or unfulfillment were not personal failings, but systemic results of their domestic confinement. This was the psychological engine of the divorce revolution. A woman who realized her own worth through a consciousness-raising group was far more likely to seek a divorce than a woman who remained isolated in her kitchen. The potential outcomes of these groups were profound. They provided the emotional support network that allowed women to walk away from the financial security of a marriage. At the same time, the American male was undergoing his own psychological crisis. The 1960s introduced the concept of the midlife crisis into the popular imagination. Men were being told that they were trapped in a gray corporate existence, and that their wives were part of the cage. The media began to celebrate the man who left it all behind. Job, the house, the family, to find his true self in a cabin or on the road. This wasn't seen as abandonment. It was seen as a brave quest for authenticity. The psychological cost to the family was often ignored in favor of the narrative of individual liberation. Data from the end of the decade shows a massive shift in public opinion. In 1960, a majority of Americans believed that divorce was a moral failure. By 1969, A growing number of people viewed it as a legitimate path to personal happiness. This wasn't just a change in opinion, it was a change in the American character. We were becoming a society that valued the individual over the institution. We were trading the long-term stability of the community for the short-term satisfaction of the self. As we stand in 2026, we can see that this psychological revolution was a double-edged sword. It allowed people to escape truly toxic and soul-crushing relationships, but it also made the exit much easier for those who were merely bored or going through a temporary rough patch. The 1960s taught us that our feelings were the ultimate authority, and that if a marriage didn't feel good, it must be wrong. This legacy of emotional volatility continues to shape the way we approach relationships today. But by 1969, as the legal, religious, media, and psychological walls had all been breached, the United States was about to enter a new era. The 1960s had been the rehearsal, but the 1970s would be the performance. The divorce rate was about to go into a vertical climb that would leave no family untouched. As the clock struck midnight on December 31, 1969, the American family as it had been known for centuries was officially a thing of the past. In the final part of this masterclass, we are going to tie it all together. We will look at the 1970s cliff, the decade where the divorce rate reached its historic peak. We will look at the long-term legacy of the 1960s revolution on the children of that era, who are now the grandparents of 2026. And we will answer the ultimate question. Did the 1960s divorce revolution deliver on its promise of a happier, more fulfilled America? Or did it simply trade one set of cages for another? The conclusion of this journey will change the way you look at your own family history forever. The 1970s did not just arrive. They erupted from the tectonic shifts of the late 1960s. If the 1960s were the period where the cracks in the American domestic foundation first appeared, the 1970s were the years the entire structure was leveled and rebuilt into something unrecognizable. To understand the legacy of 1969, we have to look at the statistical cliff that the United States drove off as it entered the new decade. In 1960, the divorce rate was roughly 9.2 per 1,000 married women. By 1970, that number had climbed to 14.9. But by 1979, it hit an all-time historical peak of 22.6. This was not a gradual incline. It was a vertical spike. This data tells a story of a nation that had spent 10 years gathering the tools, the legal permissions, and the psychological justifications to finally walk away. Imagine a character named Gary. In 1965, Gary was 5 years old, living in a suburban neighborhood where every house had a father who came home at 5:30 p.m. By 1975, Gary is 15, and his world has transformed. Half of his friends now live in what the media calls a blended family. Gary's own parents were part of the 1969 California wave. He has grown up as a member of the first generation to view marriage as a conditional arrangement rather than a permanent status. As we look at Gary from the year 2026, he is now an elder in his 60s. His life has been a case study in the long-term potential outcomes of the 1960s revolution. He has been divorced twice himself, a trend sociologists call the intergenerational transmission of divorce. The 1960s didn't just change Gary's childhood, they changed his internal blueprint for human connection. Step by step, the 1970s saw every other state in the Union scramble to catch up with the California model. The legislative dominoes fell with incredible speed. By 1974, even the most conservative states were being forced to reconsider their fault-based systems because their citizens were simply crossing state lines to get their divorces elsewhere. This created a race to the bottom for residency requirements. The Reno divorce ranch was being replaced by the local courthouse. The legal establishment, which had fought the DIY movement so fiercely in 1968, realized by 1972 that they could no longer hold back the tide. They pivoted from gatekeeping to management. The focus of the legal system shifted entirely to the administrative processing of what had become a mass-market experience. This era also saw the final death of the alimony model as a form of moral restitution. Historical trends show that during the 1970s, the term alimony was increasingly replaced with maintenance or spousal support. This wasn't just a linguistic change. It represented a fundamental shift in the economic philosophy of the state. The idea that a man owed a woman a lifestyle for the rest of her life because he had broken his vows was replaced by the idea of rehabilitative support. The goal was now to provide just enough money for a short period so the former spouse could gain the skills to enter the workforce. For the women of the 1960s who had been promised a lifetime of security in exchange for domesticity, This was a breach of contract on a societal scale. They were the casualties of a revolution they often didn't ask for. Consider the case studies of the 1970s displaced homemaker. These were women in their 50s and 60s who found themselves divorced under the new no-fault laws with no professional skills and a rapidly diminishing support check. Their plight led to the creation of the first advocacy groups for divorced women, which in turn fueled the push for the Equal Credit Opportunity Act of 1974. This is a critical point. The divorce revolution of the 1960s was a primary catalyst for the financial liberation of women in the 1970s. Because the safety net of marriage had been removed, the state was forced to provide women with the legal tools to build their own safety nets. You couldn't have a society where half of all marriages ended in divorce if women couldn't own property, get credit, or sign leases on their own. The psychological impact on the children of the 1960s, like Gary, began to manifest in what researchers called the sleeper effect. In the late 1960s, experts had claimed that children would bounce back quickly. But as these children hit adulthood in the late 70s and 80s, longitudinal studies began to show a different reality. They often struggled with a deep-seated fear of abandonment and an inability to trust long-term commitments. They were the ones who pioneered the concept of living together or cohabitation as a way to test the waters before committing to a legal contract they had seen fail so spectacularly. By 2026, cohabitation has become the standard precursor to marriage in the United States, a direct legacy of the 1960s disillusionment. As we conclude this retrospective, we have to look at the broader cultural victory of the individual. The 1960s succeeded in making the pursuit of happiness the primary metric of a successful life. The social stigma that once kept miserable families together was effectively erased. In 1960, a divorced person was a social failure. By 1970, they were a person who had successfully transitioned. This was a massive win for human agency. It allowed people to escape abuse, neglect, and soul-crushing boredom. But it also introduced a new kind of instability into the American middle class. The family home, once the most stable asset in the economy, became a liquid asset that could be sold and split at a moment's notice. The 1960s divorce revolution was not a single event, but a complex web of legal, religious, economic, and psychological changes that converged at a unique moment in American history. It was the decade where the United States decided that the cost of freedom was worth the risk of instability. We traded the security of the cage for the uncertainty of the open road. As we look at our own family trees in 2026, almost every one of us has a branch that was reshaped by the events of 1969. We are the heirs to a revolution that we are still trying to understand. We have explored the staged hotel photos, the Reno ranches, the religious revolts, and the rise of the divorce predator. We have seen how a single signature by Ronald Reagan changed the lives of millions. But the story of the American family didn't end in 1969. It was just getting started. The 1960s tore the old house down, but the 1970s were the years where we had to learn how to live in the ruins. What happens when the divorce rate hits its peak and a new generation of fathers begins to demand their rights? What happens when the legal system realizes that the 50-50 split isn't as fair as it looks on paper? And how did the children of the 1960s eventually find a way to build stable homes of their own in an era of total domestic uncertainty? Our journey through the history of the American family is far from over. In our next deep dive series, we are moving into the neon-soaked, high-conflict decade of the 1970s. We will examine the rise of the joint custody movement, the introduction of the best interests of the child standard, and the celebrity trials that turned the courtroom into a national theater. Get ready for the next chapter in the survival of the American heart.